The meeting of the Public Safety Committee is now called to order. Mr. Clerk, would you please call the roll?
Alderman Boyd.
Present.
Alderman Vaccaro. Alderman Cone. Alderman Arnowitz. Alderwoman Hubbard. Alderman Kotar. Here. Alderwoman Spencer.
Present.
Alderman Muhammad.
Present.
Alderwoman Boyd. Chairman Kennedy.
Here.
President Reed.
Here.
We have a quorum.
Thank you. Would you please excuse Alderman Vaccaro, Cone, Arnowitz, Hubbard, and Alderwoman Boyd. We'd like to thank everyone for indulging the committee. The Housing Committee went long today, so that's why we're starting a little bit later than scheduled. We thank you for your patience in that. And then it took a little time for transition to get the proper bills before us here today. We have 3 bills on the agenda today. We're going to pick up, we have Board Bill 134, 233, and 234. We will start with Board Bill 233. Alderman Boyd is taking up the bill for Alderwoman Boyd.
That's right, Boyd and Boyd. Good morning, members of the committee. Board Bill 233 is a real simple bill. As you may remember, we passed a civilian review board bill in the past, but what this bill does is provide subpoena power. And this is something that the community was asking for. Many of us on the committee and many members of the Board of Aldermen supports that. I know the mayor has come out publicly and supported subpoena power for civilian review. So this is the bill that's before us. I do have an amendment to the bill that I would like to ask to put before the committee. So I would like to move that amendment number 1 be put before the committee for discussion.
Second. Been moved and seconded that we put amendment number 1 before us. It is before everybody. You do have it, okay? It's been moved and seconded that we place amendment 1 before the committee. Is there further discussion on the amendment? If no other discussion.
Okay. Well, basically what amendment number 1 does, it makes it clear on who issues the subpoena and enforceability of the subpoena. So that's just some basic language that was added. And again, it's a pretty simple bill. Mm-hmm. I'll take any questions anybody might have.
Let's go ahead and, I don't see any questions from anyone. Let us go ahead and adopt the amendment.
Okay. I move for adoption of amendment number 1 to Board Bill 233.
Been moved and seconded that we adopt amendment number 1 to Board Bill 233. Any discussion on the motion? If not, Mr. Clerk, would you call the roll?
Alderman Boyd.
Aye.
Alderman Vaccaro. Alderman Cone. Alderman Arnowitz. Alderwoman Hubbard. Alderman Kotar.
Aye.
Alderwoman Spencer.
Aye.
Alderman Muhammad.
Aye.
Alderwoman Boyd. Chairman Kennedy.
Aye.
President Reed.
Aye.
We have 6 aye votes.
By your vote, you sustain the motion from the Alderman from the 22nd. On to the bill.
Any public testimony? Is there any public testimony?
No.
Okay. Well, with that, Mr. Chairman, if no public testimony, I move for a due pass recommendation on Board Bill 233 as amended.
Second and previous roll.
It's been moved and seconded that we adopt amendment Board Bill 233 as amended. There's been a request for previous roll. Is there any opposition to previous roll? Seeing no opposition.
Mr. Chairman?
Yes.
Did anyone want to speak about the importance of this bill?
Would any committee member?
Or this is
No, we're not taking public.
Mr. Chairman, if
We
I
have
may,
others to speak about it.
on Board Bill 233, providing civilian oversight to, or excuse me, subpoena power to the Civilian Oversight Board, I thought it might be prudent to just weigh in for a moment on the importance of this.
You have some comments?
Sure. I mean, I think this is a great day for some additional oversight of our police department. We have a new police chief and new public safety director that I think that the city has broad support for, and I'm glad to see that moving in the right direction. This has been a long time coming. I know that many members of our board took the lead here. I'm grateful to see that, and I'm just proud to be a co-sponsor, and I'm glad that this day has finally come. This is something that the public has been wanting for a very long time, and I'm really happy to see us finally be able to adopt this.
Thank you.
Any other comments from members of the committee? If not, you renew your motion.
I renew my motion, Mr.
And there's
Chairman.
been a request for previous roll. Seeing no opposition to previous roll, by your vote, we have adopted Board Bill 233 as amended. Thank you. We'll now take up Board Bill 134. Mr. President, I know you have to do that. I know you have to do that.
Yes, I have the committee substitute, and then just another copy of the current allotment, and a copy of the federal change.
Alderwoman?
Thank you, Mr. Chairman and members of the committee. I have a committee substitute that I think Lou is handing out now that I would like to go ahead and introduce.
You can go ahead and discuss it, Daisy.
Okay.
Puts it.
Basically, from the last meeting that we had on this back in, I believe it was late October, early November, there's just a couple of minor changes that we made to the bill. First off, I'll go over just as a refresher what the bill does and doesn't do. Basically, it repeals our constitutionally vague definition of unlawful assembly to ensure that officials do not declare a constitutionally protected assembly unlawful. It establishes a First Amendment policy for the city, which is designed to safeguard free speech and set guidelines for officers. This was created using the Washington, D.C. Ordinance as a template with the input and the assistance of the ACLU and the MacArthur Justice Center. It requires that officers provide clear and audible notices for when to disperse or how to comply with requests from officers. It mandates that our police shall not take an action to prevent or interfere with the ability to record or observe what is going on. Last time we heard this bill, we had a number of live streamers and members of the media who came and testified in support as well. Specifies that law enforcement must wear clearly visible name tags, that we must process arrestees and release those eligible for immediate release, and it limits the use of chemical agents on individuals to not allow their usage when people are already restrained, and must give clear instructions on how to disperse that are audible from 40 feet away. It also requires that officers must give a clear time for people to be able to vacate. This bill takes a step forward in a couple of areas. The Ferguson Commission report asks us to develop a comprehensive demonstration plan, and this is a first step in doing that. And it also gets an unconstitutional ordinance off of our books. And so I went ahead and I passed out, just to refresh everybody's memory, what our current unlawful assembly ordinance is. And that ordinance is very unclear to, I think, a lot of folks, and without a policy in line that actually allows both protesters and officers to know what it means and what it stands for, then it's very difficult, I think, to follow the law. The other thing that we passed out here is the order of preliminary injunction. So since we last met, when we met at that time, we discussed how when we drafted this board bill, we did so in alignment with the federal injunction that was filed by the ACLU to make sure that if that passed, then or if the federal injunction was granted, that our new unlawful assembly ordinance would mirror whatever the recommendations were from that federal injunction. So this was also emailed out in advance so that folks could compare the two. With that said, the changes that we made to the bill were essentially, on the first page, we could not find the original ordinance number for the unlawful assembly ordinance. We could find the municipal code, but after hours and hours of research and digging through guidelines or digging through past ordinances, nobody could find the actual number. So we had to update that to recognize what we were actually repealing. And then in the section of on page 6 through 10, there was some updated language regarding how quickly folks must be processed through the system if they are arrested during a protest. So none of this holding people for 36, 48 hours if they're not actually being charged with anything, and also a requirement that folks that have medical needs, that take medication, that is given to them while they are in custody at the Justice Center, and nobody is denied access to medication. So those were the two real changes that were made to the bill, just to make sure that everything was in alignment with the federal injunction, and I'd be happy to answer any questions.
I was just trying to get the committee sub in front of me.
Okay.
Everybody else got it. I didn't get that. Okay. All right, we can take questions from members of the committee at this point on the committee sub. Alderman Boyd?
Yes, I have a question, if you wouldn't mind, Mr. Chairman. I have a question that may not be specific to this bill, but could potentially be germane to this bill. You're in support of Board Bill 34, which is the buffer zone bill, is that correct? Mm-hmm. And the buffer zone bill basically prohibits people from coming within 8 feet of a space, correct? So on page 6 of your board bill, line 14, it says arrests should not be made on the basis of a municipal violation unless necessary to avoid a clear and imminent danger to public safety by way of violence and physical harm. Mm-hmm. So wouldn't this contradict Board Bill 34, the buffer zone bill?
I'm actually not sure.
It sounds like it, though.
I know that the ACLU helped with both board bills in providing some legal guidance on it. I think that the intent here is that there has to be some kind of threat to bodily harm, to physical violence.
So that becomes subjective then. And I'm just looking on its face, and of course I'm not a lawyer, sometimes I pretend to be one, it gets me in trouble. Mm-hmm. But on its face, that particular language seems to contradict what Board Bill 34 is trying to do. So I just want to point that out.
Okay.
I have no further questions, Mr. Chairman.
Alderman Kotar, any questions?
Mr. Chairman, I don't have any questions at this time. I'd just say, you know, we've got a new public safety director, a new police chief that I think many of us have the utmost confidence in, and I'd like to give them an opportunity to run their department before we start dictating policy to them. Thank you.
And I completely agree with that. You know, I think that the chief and the public safety director are doing a phenomenal job. I also think that, well, we had our first lawsuit that was filed against the city seeking monetary damages last week for actions in violation of the federal injunction. And I think that that is just going to be the first of many lawsuits that we see having come against the city in the coming weeks and months. So I think it's imperative from our point of view to be able to show that we are codifying new requirements as those lawsuits continue to hit the city.
Alderwoman Spencer?
Thank you, Mr. Chairman. And I'd like to thank the sponsor for bringing this before us. I think this is an issue that we as a city have agreed. There's been very alarming issues with regards to protesting in our city. My concern with this particular bill and the movement here is that there are issues of broadness. It is an overly broad bill. You know, I mentioned previously that our city has really we have a new public safety director, a new chief of police that our city is showing a lot of support for, myself included. I'm hearing concerns from the leadership, our new leadership at the police department, that while we want to address some of these issues, they need to be done in concert with the police leadership. And those concerns, I think, need to be addressed before we move forward with a bill that has such long and broad implications.
I appreciate that. I also think that the longer we wait, the more it allows this ordinance that nobody knows what it means to stay on our books. And like I said a minute ago, Mike Falk just filed his first punitive, damages lawsuit against the city last week. And I know that there are several other lawsuits that are in the pipeline. And so I think from a point of view of as those lawsuits are coming against the city, it's important for us to be demonstrating that we have taken the guidelines of the federal injunction very seriously by repealing the ordinance that they find so problematic and replacing it with what their recommendations are.
What I don't want to do is repeal an ordinance that's problematic and replace it with another ordinance that's problematic. And given that our leadership is not at a point with this bill to even feel comfortable speaking about it, I do think there's a little more work to be done. While we do have a break coming, it's a very short break, and we can use that break to collaboratively work with our new director of public safety, our new police chief, and come up with something that is going to be not only enforceable by the police department, but protective of our community. I don't think we're there yet, and that is my major concern with this. Not that this isn't a step in the right direction or getting us where we need to go, but that it's not there yet. We do have a problematic ordinance on the books. I do not want to replace one problematic ordinance with another problematic ordinance.
And I also agree with that. And I guess my refute to that was I would think that crafting an ordinance that verbatim follows what the federal injunction says, while also implementing the best practices of Washington, D.C., does not create for a problematic ordinance. And I think that folks are looking for us in the community to be proactive on this, and I think that delaying this any further demonstrates that this is not something that we have urgency over, and that would be my concern from a protecting the public point of view.
And again, out of respect for our new public safety director and our new police chief, I'm going to, again, voice my concern with moving forward without having that constructive dialogue with them participating.
Alderman Muhammad.
Thank you, Mr. Chairman. I have several questions just regarding the content and the language of the bill. In Section 3, subsection D, it says a significant number or percentage of the assembly participants, so on and so on. Exactly what is a significant number?
So I think when we were crafting it, we had to leave it vague enough that we could give flexibility to the police in determining what a significant number is. To me, it would be more than 50%. And I would also think that you know, if an issue ended up in court again, it would be up to a judge to really rule what that means.
So it's open for interpretation?
It is, and a lot of this is, and this was language that was taken from the Washington, D.C. ordinance. And I think that, you know, the concerns that we had is we didn't want to narrowly tailor something too much that it made it impossible for the police to be able to respond, you know, to an emergent situation. We didn't want to tie their hands in a place where they really need to be able to step in.
So I think that that needs to be strengthened in some type of way when you say a significant number and you leave it open for interpretation. And an officer gets to choose what significant actually is, whether that's 20 people or 200. I think that that's problematic. Furthermore, Section 3 again, subsection E2, except where there is imminent danger of personal injury or significant damage to the property, so on and so on. Who determines that this protest or assembly is a matter of imminent danger?
So in the definition sections, I think that that's covered through the unlawful act of force or violence. That is what we are using as something that intentionally causes or attempts to cause injury would then trigger that.
So basically, the police department gets to determine exactly what's a significant number, and it gets to determine if they're in danger or not. So that's also open for interpretation.
I mean, any First Amendment policy that we have is still going to have a certain amount of discretion for the police in it.
Going on to the 5th page, officers shall obtain supervisory approval to be documented soon, so on and so on. At exactly what level do they need supervisory approval? Does that come from the chief? Does that come from their captain? Or would that come from the director of public safety?
Would be whoever is directly above that person that person reports to at that situation.
So that's also open for interpretation, because if I'm an officer and my sergeant is on the scene, I'm going to go to my sergeant. What if my commander is on the scene? Who do I go to?
It's what your chain of command is.
So how do we ensure transparency with that chain of command? Because it just says supervisory approval. It's not really detailed.
I mean, within the police department, there is a chain of command of who you are supposed to go to and talk to.
But in a case of, let's say if this was an emergency, in case of emergency, we have 200 protesters outside right now. Who do I go to?
You go to whoever your supervisor is, whatever your chain of command is.
I think that's problematic. And I'm closing, Mr. Chairman. Looking back at the most recent protest that took place with Jason Stockley, we had St. Louis County Police also patrolling and doing their best to contain us, and I think they failed. Will this same ordinance and this same policy, does that require any policing agency to adhere to if they are patrolling in the city of St. Louis?
Anybody within the city of St. Louis that is involved in that coordinated command structure that goes into place when we are sharing police resources between departments.
Now, what if, let's say Chief Barrymore says, to hell with this policy, my office don't have to follow. How do we, what's the steps after that?
They would be subject to a lawsuit for violating this. I mean, any group of police officers that are in the city that the city is using to carry out our police duties would have to abide by this within the city limits.
But there's no,
And I think one of the important things that this does is it requires that, you know, being able to visibly see who that officer is and what department that they are representing. So I know a lot of times during the protests, you have no idea which department somebody is from, who their name is, and one of the requirements in here is that there is that visibility, so that we can really see who is here.
I find some of the language to be a little weak and a little lacking, and I think if it was strengthened, it could be a hell of a bill. But in its current format, I think that it's left open for anybody to assume what the bill is and assume how to carry it out. And I also agree with the Alderwoman from the 20th Ward. I think that we should allow the new leadership, as it relates to the police department, I think that we should allow them to come up with a plan as it relates to containing or peacefully overseeing protesters as we protest, regardless of what the matter or circumstance may be. Have they been included in the construction of this?
No,
bill?
we drafted this before we had either one in place.
Gotcha. Mr. Chairman, if I may, I would be curious to know how the Director of Public Safety
If I may, I would be willing, you know, to table this and bring it back as soon as we come in next session to address these concerns. I will say, though, that I am making a firm commitment that this will come back, that this has to be done, this has to be codified. This cannot be something that is left up to internal police policy that can change depending upon who is in charge. And so I'm okay to do that, and if you, and if Alderman, you would like to sit down and tell me whatever your concerns are, I'm happy to do that. I just want to make sure that there is an understanding that this really does need to be codified and not left up to internal police policy.
Thank you, Alderwoman. No further questions,
Okay.
Mr. Chairman.
That completes all the questions from members of the committee. I understand, Alderwoman, do you still have any questions? Alderwoman? You're fine? Okay. All right. Are there any other questions from members of the committee? If not, then we'll go ahead and hold the bill and
Yes.
give more time to work on it.
Okay, thank you.
And see how you move from there.
Thank you.
All right, thank you. We will now take up Board Bill 234, sponsored by Alderman BOSLEY.
Good morning, Mr. Chairman, members of the committee. Board Bill 234 is basically setting up internal investigation unit for the Circuit Attorney's Office when there's a police-involved shooting in its simplest form. We are asking for 1% of the police, the St. Louis Police Department's annual budget. What I also kind of want to look at with that is getting some numbers together on exactly what it will cost, because I think that is one big question that a lot of people need to have answered as far as where this money, not where it'll come from, but how to be allocated, and what will be taken away from the actual police department. So with that, of course, you all know it's a lot to the bill, so let's get to the questions, if we got any.
Mr. Chairman.
I'm sorry, Mr. Chairman.
Yes,
Yes, sir.
what did you say? Are you completed with your
Yes,
comments?
sir.
Oh, okay.
It's cut and dry to me.
Are there any questions of the sponsor at this point? I know we have other opportunities. Alderman Boyd,
Not at this time, Mr. Chairman.
Alderman Coder.
Yeah, Mr. Chairman, I guess for the sponsor, I'd ask sort of a basic fundamental question about how you have this thing set up. When you say an amount equal to 1% of the annual budget of the City of St. Louis Division of Police, have you talked, can we budget this way? Can we allocate funds in this manner? I mean, outside of the normal budget process, earmark, you know, basically 1% of some other department's budget, which is a number to be determined, and an amount equal to that to another department. Is that, can we do that under our rules? I actually don't know the answer. That's why I'm asking.
You know, I've seen it done before, and I don't know anything that would prevent it from.
Okay. I guess so then my next question would be 1% of the annual budget of the City of St. Louis Division of Police. Is that, so right now, I guess the police budget's, I wrote this down, $136 million is the police budget, and then another $31 million for the retirement fund. So are we talking 1% of the $136 million or 1% of $166 million?
1% of the 136.
Okay. That's
Not the
all,
retirement
sponsor.
fund.
Thank you.
Thank you. And we do have other speakers. Alderman Spencer, do you have any questions at this point? We can always come back.
I would prefer to come back after all the speakers.
Okay. Alderman Muhammad, anything to this point? That we can return.
No, sir, I yield.
All right. Then with that, we will call up our next speaker.
Okay.
Okay.
Thank you.
We have Mr. Brian Milliken, if I'm pronouncing that correct, representing the Police Association, an attorney for the Police Association.
I am. Thank you.
Please identify yourself for the record and then.
My name is Brian Milliken. I'm an attorney. I represent not only the St. Louis Police Officers Association, but officers throughout the region involved in either internal discipline or critical incidents. Mr. Chairman, I do have a handout for
Just
each.
give to the clerk here, get it out to her.
Thank you, Mr. Chairman, members of the committee. Thank you for having me here today to talk about this important issue. What I've handed you is basically two things, a copy of the presentation I'm about to make and also a copy of the Force Investigation Unit policy in its current form. I'd like to start by giving you a basic history and overview, and I'll try to get through this quickly as I know there are other speakers and we're limited on time. But basically, prior to the Force Investigation Unit being created back in 2014, critical incidents were handled by the Homicide Division of the St. Louis Police Department. That's how the majority of these incidents are handled by departments throughout the region. There is no specially assigned unit to handle these incidents. I think the department realized back in 2013 and 14 that these incidents were different. They were important to make sure that there was transparency and that they were done correctly. And so they formed this unit called the Force Investigation Unit. The department literally spent hundreds of thousands of dollars training its investigators, buying equipment, so that these detectives who typically come out of homicide or some other unit that they have a lot of experience already in investigating these types of incidents. But they took the extra step to send them around the country and to gain training in the dynamics of officers-involved shootings and shooting scene preservation and construction. The policy incorporates the best practices from around the country, namely from the FBI, and I can tell you that in traveling across the country and meeting with other lawyers who do what I do, this is the most comprehensive policy that I have seen, okay? Many departments in our region don't have a policy. St. Louis County, for instance, doesn't. And I just want the committee to understand how much time and effort has been put into this policy. I think one of the misunderstandings that I see in talking to people is that people believe that the Force Investigation Unit is responsible for making charging decisions, and that is absolutely incorrect. The unit's sole and primary responsibility is to collect facts and evidence. They then present that information to the Circuit Attorney's Office under the current policy, and the Circuit Attorney's Office then makes a charging decision. So how does just practically speaking, how do these incidents, how does it work? What's the process? If there's an officer-involved shooting, the first thing that will happen is that the involved officer will call it out, obviously, and the scene will be secured. An initial supervisor will respond, and he will get what's called a public safety statement. This is the first statement that an officer is required to give in one of these cases. And I want to talk about the difference between a compelled statement and a voluntary statement because it's very important in understanding why police officers oppose this particular bill. They give a public safety statement, and it's very basic. It's the nature, description of suspects, direction of suspects, whether anybody's been injured, location of evidence. And they give a very general description of what occurred, but that's it. After that, they are taken to the Force Investigation Unit, where a number of things occur. Number one, as part of the internal investigation, officers are required and compelled to submit to an alcohol and drug screening. This is the only officers that I ever represent that have to go through this sort of procedure. They're screened, but these are not voluntary screenings. They are compelled, and therefore they do not, the results are not contained in the FIU criminal investigation report that goes to the Circuit Attorney's Office. Their guns, magazines, and ammunition are seized as evidence, and they're asked to voluntarily submit to a buccal swab for DNA-related evidence. Photos are taken, and then that's kind of the end of the process up to that point. Thereafter, they're at some point asked to give a voluntary statement to the FIU investigators. Again, I use the word voluntary because that's exactly what it is. These are criminal investigations. They have all of the rights that any other citizen of the United States has when it comes to a criminal investigation. They can give a statement. They cannot give a statement, okay? But if they do decide to give us a statement, these statements are given on mutually agreed terms by both the officer and the investigator who's conducting the statement. Therefore, the FBI has come out with a series of studies that have said that officers, in order to get the best and most detailed statements, officers should be given at least one sleep cycle before they are asked to give a statement, okay? That's where that comes from. I know that there's been talk about why do policemen get preferential treatment. It's not preferential treatment at all because these are voluntary statements. They must be agreed to by both the officer and the investigator on a time and place. But the best practice, at least according to the FBI and the studies that have been done, are that they should get at least one sleep cycle. So again, voluntary versus compelled. Voluntary statements are given to FIU in connection with the criminal investigation. These statements can be used for any purpose, including prosecuting the involved officers. Compelled statements, on the other hand, are given to the internal affairs investigators. They are compelled under the threat of discipline, and they are not part of the criminal investigation and are therefore not contained in the FIU report. These statements cannot be used against those individual officers in a criminal proceeding. So what we have tried to do is balance these rights of the policeman, of the individual policeman, with the desire, their need and desire to prosecute these cases. I can tell you that talking to attorneys around the country, that the national trend is to not give a voluntary statement. And the theory goes that because these policemen are the subjects of criminal investigations, they should be counseled like any other suspect in a criminal case. Typically, when a suspect has a lawyer, he will not give a statement. But again, we have tried to balance this out, and I can tell you, at least with the officers that I've represented, and I've represented many of them, every single person, every single officer has given a voluntary statement to FIU since its creation. For these officers to continue to cooperate in the fashion that they do, they need to trust the system in which they are operating under. I understand the public needs to trust the system as well, okay? But it's not just the public. It has to, this system has to be balanced and fair if these officers are going to continue to give voluntary statements. If they don't give voluntary statements, what you will end up with is an investigation that likely can't be fully completed. Especially in those cases where you have an officer and a suspect, there's a shooting, and there's no video, they're in an alley, there's only the officer's testimony, and if he doesn't give testimony, where are we at that point? Again, the officers, it's extremely important that they have confidence in the system in which they are operating. There are a number of reasons why the trust in the system, at least with the people that I've represented, there's a number of reasons why that trust has eroded over the last year or so. I'm not going to get into all of those at this point. They're in your materials. I would just say that, trust me when I say that officers are very distrustful at this point in time of where we're at. Second thing I'd like to talk about are investigations and reviews and the difference in those two things. Investigations are typically conducted by a police agency. A police agency with investigators who have been trained and are professional in securing scenes, in interviewing witnesses, in processing evidence. They do not make charging decisions. They should be separate and apart from the agency or entity that is making the charging decision. The reviews, on the other hand, are conducted by typically a lawyer, a circuit attorney, special prosecutor, or the Attorney General's office. They review the information. If they don't see enough information or if they have questions, they can go back to the investigators and ask that more investigation be done. But they should be separate so that you have different agencies, one a police agency whose sole responsibility is to gather information and facts, and the circuit attorney or the special prosecutor or attorney general who would then review those facts and make a charging decision based on the law. What's also interesting is that there are multiple investigations and reviews already on the books. These incidents are incredibly scrutinized. They're highly scrutinized. They are the subject of at least 6 and sometimes 7 investigations and or reviews. The Force Investigation Unit, the Internal Affairs Division, the Deadly Force Tactical Review Board, which is made up of a number of commanders and people within the department, the Civilian Oversight Board, the Circuit Attorney's Office, in some cases the United States Attorney's Office, and the Post Commission, which is the state entity which issues and disciplines peace officer certifications at the state level. What we are looking for and what we desire, and what everyone should desire, is an unbiased investigation. They should, again, be conducted by experienced professional investigators with no agenda other than seeking facts and evidence. They should not be desired by an outcome or result, or influenced by a desired outcome or result. And in my view, in looking at all of the different departments that I deal with, FIU is the most highly trained, experienced, and well-equipped unit in the state. And I believe that they should continue to investigate these incidents. Politicians who have a political interest in these cases should not be leading these investigations. On the review side, we agree with the Ferguson Commission when it recommended that the Attorney General's office review these investigations. If the Attorney General's office isn't an option, let's say they wouldn't agree to take these investigations and review them, we agree with candidate Kim Gardner, who stated numerous times during the election that a special prosecutor should handle reviews of officer-involved shooting cases. And I quote from a 15th Ward questionnaire, her answer, that a special prosecutor should be appointed for the sake of appearance and maintenance of trust. She says, I support the use of an independent prosecutor in these instances. I agree. If special prosecutors are appointed, we would endorse that over the Circuit Attorney's Office handling these reviews. The whole point here is that, you know, again, we have to have a system that everyone trusts, not just a certain population or segment of the community trusts. Everyone should trust it, and it's very important, it's vital that police officers trust it so that they continue to cooperate in these investigations. And otherwise, we're going to end up with a situation where, like other parts of the country, where there aren't voluntary statements being given. I thank you for your time, Mr. Chairman.
Thank you. We'll take questions from members of the committee.
Yes, sir.
Alderman Boyd, are there any questions?
Sure, I have a couple of questions. Can you define what a sleep cycle is for me?
A sleep cycle, I believe, is defined in well, let me interpret it for you. My interpretation is whatever a normal officer's sleep cycle is. Some people get 6 hours a night, some people get 8. I guess it would depend on the individual officer.
Okay, you did provide us with a copy of, let's see, this is a special order. I haven't had a chance to go through all this. I'm trying to go from memory. I remember having a public hearing and Major Warnicki said that a police officer gets 48 hours before making a statement. Is that correct? Does that sound right?
That is incorrect. What the policy states is that the statement will be given, if given, at a mutually agreed upon time. That's it. It doesn't say anything about sleep cycles.
So it could be a week.
It could be a week, it could be never, it could be a month, it could be that day.
Okay, so let me ask you this. So if a police officer shoots and kills somebody, you're saying that it could be whenever before they give a statement about what happened?
It could, on the voluntary statement side, yes. Now, they can be compelled to give a statement right then and there. As a condition of their employment under threat of discipline up to and including termination, they can be compelled to give a statement at that particular time.
But it's not, but certainly there has to be a policy in place that they will give a statement within a certain minute of time. You can't just say voluntary whenever, and there's no policy in place right now that says they will be compelled after expiration of a certain amount of time, right?
Well, okay, let me answer. It's a good question. I'm glad you asked it because, again, that's why I'm talking about the difference between a voluntary and compelled statement. We haven't, Alderman, we have not had up to this point an occasion where a police officer has not given a voluntary statement. So I'm not sure at what point the department would say, okay, if you're not going to give a voluntary statement, you're coming in now and we are going to compel a statement from you. And at that point, they would have to give a statement.
Okay. I'm almost sure that we were told 48 hours, but I could be wrong. So I'll have to go back and look at the research, which I found was unfair, that you have 48 hours to come up with your thoughts about how the situation went down.
I would urge you to think about it in terms of the police officer being a suspect in a criminal investigation.
Yeah, but I also think about it and when a citizen is a suspect in an investigation because they may have shot somebody. And I don't think the police officer is going to wait until weeks on end before they make a statement. And the prosecutor's office is not going to wait, you know, they want a statement right now about what happens, right?
But that person's not required to give a statement. They have a Fifth Amendment constitutional right to not give a statement.
Okay, so that'll be a question for the circuit attorney. Okay, the other question is, because it sounds like you're doing some character assassination, which has really kind of turned me off, but I'm gonna put my feelings aside. Is it your position that police officers have been held accountable for their actions in the past always?
In representing policemen, I often, you won't agree with this, but I often feel like they are overly disciplined at times. And that's just from my personal experience. I can't speak to every occasion or every instance, but I can tell you I think that from my experience, they are held to a different standard, certainly, than other people.
And you represent the police, is that correct?
I represent individual officers in these cases.
Right. And
that's
so
correct.
in your capacity of representing police officer, I would hope that 100% of the time you think that they're probably over-policed or it's harsh punishment. That stands to reason, right?
I admit that I am not.
It's bias.
I am biased when it comes to this.
All right.
Based on my experience.
So let's talk about unbiased opinion. So explain to me, politicians who have a political interest in these cases should not be leading the investigation. What are you talking about? Explain that again.
Okay, so, and I really, I apologize if I've offended anyone. I'm just trying to make you understand why there is a feeling within the police ranks of not having a fair process in place.
No,
okay?
I understand that, but explain this statement. Politicians who have a political interest in these cases should not be leading the investigations. Who are you talking about? What are you talking about?
There have been a number of actions that have been taken by the Circuit Attorney's Office that, in a court, actually agreed that there was an appearance of impropriety here, a month or so ago, based on actions that have been taken within cases, and we would have to get way into the weeds on what the actions meant and why they have an appearance of impropriety. But there have also been statements made, such as, we need to hold police officers accountable, which implies to a policeman, it implies that they haven't been held accountable in the past, and the only way to hold them accountable from a circuit attorney's perspective is to charge them in cases. And so there is a perception, and of course, perceptions for people are reality, whatever their perception is, that we're dealing with a situation where these cases are not based off facts, but sometimes politics.
Well, I'm not sure that's fair because there are police officers that get disciplined within the ranks,
sure,
right? And so you can argue almost the same position. And to suggest that politicians have a political interest, I guess I'm trying to figure out an example of a political interest, because what it sounds like to me is the circuit attorney should recuse herself from investigating any police-involved shootings. So explain what political interest, give me just an example of a situation, you can hypothesize it if you want to, of a political interest with a politician that should not be leading an investigation.
I'm not going to hypothesize.
Well, give me reality.
I've tried. I've tried to give it from the perspective of a policeman that I talk to.
But you're giving me an opinion, sir.
I'm giving you perspective. I'm trying to make you understand.
But that's not facts. You're giving me a perspective on how you feel and how you think and how you interpret a situation. So you can't suggest that, and I'm not trying to take up for the circuit attorney, because the circuit attorney, if there's an issue, I want to deal with those particular issues. I want to deal with facts. So you can't have it both ways, is my point to you. You can't say, we think, and because of certain instances, that we don't need to do this because we feel this way. No, it's the fact that something happened and it should be a remedy, or you just feel a certain type of way and you want to have your way.
Again, this is not how I feel. I'm trying to give you perspective on how policemen feel. Now, let me answer your question.
And I know you're speaking on behalf of the police. I get that.
Let me answer your question. There are some 40 to 45 cases, to my knowledge, that are pending and that have been pending for over 2.5, 3 years that I'm aware of. The fact, from a policeman's perspective, that there aren't any decisions being made on these leaves them hanging in the wind, and they're unsure of what's going to happen. Their families are unsure of what's going to happen in these investigations. They could be disposed of based on the evidence that's available to the prosecuting attorney's office, but they've decided not to do that. Let me give you another example of why the perception is what it is. Typically, in a criminal case where there is a victim in this jurisdiction, in the 22nd Judicial Circuit, the case proceeds through the grand jury. There are two types of ways that a case can proceed to find probable cause. One is through the grand jury, one is through the preliminary hearing stage, okay? The grand jury is where all these cases have typically gone, and that's where most victim cases go for a number of reasons, but one of the reasons is to not expose your victim to unnecessary cross-examination that early on in a case. Earlier this year, we had a situation where the circuit attorney's office, the case, one of these shooting investigations, not shooting investigations, but a criminal case that had a shooting component to it, was sent to preliminary hearing. It was assigned to grand jury like they always go, but that decision was changed and they sent it to preliminary hearing, where that officer at that point will be exposed to cross-examination. It can't be explained other than the circuit attorney's office decided to treat that case differently because it was a police officer. Again, these are examples of how the perception has been built over time. It's not just one thing.
Right.
I'm trying to give you some concrete examples of how this perception has come to fruition.
Okay, so in your example, let me ask you this. So would you be suggesting that the circuit attorney only uses that particular route in cases of police officers? It's not part of doing business in the circuit attorney's office for normal citizens?
Yes, the pattern and practice of the
But you have data to support that. I know you probably think that it only applies to police officers, but do you have anything to support your statement?
Well, the judge in the case that we had this motion to disqualify her office said that in the 12 or 13 months he has been the judge of Division 25, where preliminary hearings go, he has not seen one victim case.
Okay.
So that's from the judge himself, not me.
Okay, so let me go back to 2 to 3 years. Mr. Chairman, please forgive me. I'm not trying to take up all the time, but I'm trying to learn something here. So you talk about 2 to 3 years there's been cases that's lingering out there. Yeah. So is that a failure in the prior circuit attorney? Is that a breakdown in the system that we need to fix and address? Because certainly the current circuit attorney hasn't been there 2 or 3 years.
Certainly not. Certainly not. And so, yeah, this is not all about one particular circuit attorney.
But you seem to be making about that, and I want to point that out because you give us information and you clearly put the circuit attorney's name in here, and you make certain assertions about statements that were made public by the circuit attorney with her name mentioned, as if this is something that's this new phenomenon that's been going on only because of this current circuit attorney. You even make reference to a statement that was made in the 15th Ward Democrat, and I'll read the statement. I'm going to give you my interpretation.
Okay.
The answer is yes. The question is, do you support a special prosecutor request in officer-involved shootings? Yes. Although I believe that under my leadership, the Office of the Circuit Attorney will fairly and expeditiously charge and prosecute any defendant regardless of the uniform they wear, political office, or stature in the community. For the sake of the appearance and maintenance of trust, I support the use of an independent prosecutor in these instances. Now, when I read that, that's an option. It doesn't say I will, and that would be the only process that I use. So it's an option. So I'm not sure if we can hold her to a standard of you absolutely will because you wrote something during a campaign on that. Mr. Chairman, I don't have any further questions at this time. Thank you, sir.
Thank you.
I appreciate it.
Alderman Coulter.
Thank you, Mr. Chairman. Mr. Milliken, if you could, getting back to what you were just talking about with that difference between preliminary hearings and the grand jury process. You know, for those of the folks that aren't in the courthouse all the time, preliminary hearing is in front of a judge with a right of confrontation by defense counsel, right?
That's correct.
So it's an open hearing in the public.
Correct.
And typically cases, and when you say cases involving victims, I mean, it's a criminal case, so there's always a victim. The victim can be the state, victim can be an individual.
Right.
So victim cases, meaning burglaries, robberies, stealings, cases of those nature, where there's a person that's not the state of Missouri usually.
That's correct.
Those cases go to grand jury.
That's how it's done in this particular jurisdiction.
Correct.
That's the pattern and practice.
Right. And in the instance you're talking about, we had a case involving an officer-involved shooting, correct?
Correct.
And that officer, the person that was shot by the officer did not die, right?
Correct.
And was subsequently charged with a crime.
Correct.
Was the crime they were charged with stemming from the incident involving the shooting?
They were charged with, among other things, UUW exhibiting, meaning they pointed a gun at an officer.
Okay, so, and was that charge based on a statement made by the officer who shot, I'm going to call him the suspect, who shot the suspect?
That's correct.
So in that instance, the circuit attorney's office believed the testimony or the observations and the experience of that officer was credible enough to charge the person who was shot with a felony offense, right?
Correct.
Okay, so that in my mind, and having worked in the office, that would lead me to believe that that officer's version of events is found to be credible.
I would agree with you.
Okay, so I guess in circumstances in the past, so then at some point, and maybe it's not immediately, maybe it's months down the road, but at some point, the issue we're dealing with is a matter of just, in that instance, clearing the officer, right? That officer, in order for them to testify publicly, in order for them to be under oath on the stand testifying about that incident, they want some assurances that they're not going to be criminally prosecuted down the road. Isn't that right?
That's correct.
Okay, because a police officer, as you alluded to, much like every other criminal suspect, has a right against self-incrimination.
That's exactly right.
So that officer, this could be as simply done by as simple as the circuit attorney's office in this particular shooting, where they use that officer's observations and what happened in that incident to charge a suspect, simply telling that officer and memorializing, we're not going to charge you with a crime stemming from this incident.
Based on the information that they have. That's
Right.
correct.
Okay, so with that, under that circumstance, then that officer could go forth, assist the prosecution, testify under oath, right?
Absolutely.
Okay, and that's happened for years and years with no problems.
That has happened. That's correct.
Okay, but as of late, that's not the case.
Well, I want to be fair about this because I think under Jennifer Joyce, the office issued 5 or 6 declination letters, basically saying that the officer would not be charged. And then it kind of stopped.
Okay.
But this issue did not come up because she didn't send any cases to the preliminary hearing phase, instead grand jury. So the issue really didn't come up until after Jennifer Joyce left office.
All right.
So this is, to be fair, this is a new issue for everyone.
Yeah, I mean, in my experience of criminal law, this is unheard of, this issue of, not, again, using an officer, relying on their testimony to charge a suspect, but then not also clearing that officer of any wrongdoing in that particular situation.
That's correct. And because we've had public statements to the effect that they are reviewing, at least reviewing, investigating, reviewing the officer's conduct, The officers simply want some assurances. Either they're going to be charged and they can make good, sound decisions based on that, or they're not charged and they can go ahead and proceed with assisting in the prosecution. That's all we are asking for.
Yeah, and you believe there's 40 to 50 officer-involved shooting cases that we have sort of lingering out there where no charging decisions as to the officer have been made?
Again, I don't know the exact number, but I believe it's in that area.
Okay, and obviously these are of great interest to the public, and at some point, you know, charging decisions should be made. Either clear the officer or charge the officer.
That's what we're asking for.
Okay, and we talked about your voluntary statements. Are officers Mirandized during those statements?
They are given a warning. It's not a Miranda warning, but it is a warning that they are subject to a criminal investigation and that their conduct will be reviewed by the Circuit Attorney's Office to determine whether or not their actions were justified.
Okay, so are they advised that the statements during this voluntary statement can be used against them?
That's the essence of it, yes.
Okay.
But it's not a full Miranda warning.
Okay. All right, that's all the questions I have for now, Mr. Chairman. I'll have some more about the context of the bill later.
Alderwoman Spencer?
Thank you, Mr. Chairman. Going along that, and perhaps this is a question for you, Alderman from the 7th. Why would an officer need assurances of being cleared of a crime, of being charged with a crime if they haven't committed a crime?
Well, I mean, I guess I'll answer that and then I guess defer to Brian. But I mean, in the past, I don't think there was as adversarial a relationship between the prosecuting attorney and the police where officers who did no wrong felt that there was a possibility of them being criminally charged down the road. I don't know that that's the case today, so I think officers are looking for, especially when they're being put on the stand under oath, are now looking for some assurances that what they say in the context of an open criminal case, which they were involved in, isn't going to be used against them for future charges. That never happened previously.
But if I'm understanding correctly, then a body outside of a jury, in this case, within the police department, is clearing charges of an officer based on testimony given to the police department. Am I understanding that correctly?
So I don't think we're looking for the police department to clear them. Looking for whatever the prosecuting authority is, whether it's the Circuit Attorney's Office, a special prosecutor, or the Attorney General's office, to basically look at the whole file and say, okay, we'll move forward with the criminal investigation, criminal proceedings against the suspect who was shot, and not against the police officer. At some point, you can't just have an officer under suspicion of a crime forever. At some point, make a decision, charge them or don't charge them.
And if I could add, I think what you're asking isn't it the jury's responsibility or a judge's responsibility to finally decide whether a person is guilty or not guilty?
This is precisely what I'm getting at. I know of instances in which a jury flat out didn't believe an officer's statements, and we're passing that authority on to a different entity.
Well, I would say that the only way it gets to a jury is if a prosecutor decides first to charge the person, whether it be a policeman or individual. That prosecutor has to decide whether or not they're going to issue charges. Then the case goes forward. And so it doesn't get to a judge or jury until that prosecutor makes a charging decision.
We still have concerns about making that decision before it gets to a jury. I think we can all agree that you mentioned the idea that we need to have trust on both sides, trust from the general public and trust from the police department. And I think it's clear that there are some real serious issues of trust within the general public with how these incidents are being investigated. My question to you is, how do you suggest that we improve the current system to improve the trust from the general public in prosecuting these cases?
That's a good question, and you know, I don't know what particularly people actually think or don't think, And so I don't know that I can answer that question. I can tell you that there are some practical problems with having anyone other than the agency in the jurisdiction they're in doing the investigation, especially at the moment of the actual shooting. But I don't know. That's above my pay grade to try to say or come up with a solution to a problem that, quite frankly, I don't think is based in fact anyway.
Well, we do have, what's based in fact is that the general public has very serious concerns about the process by which we are prosecuting police-involved shootings. That's clear. It was clear from the protests following the Stockley incident, and it's clear just in general. That is a problem that the general public has. And this is a solution. I understand you're poking holes in it, and you are critical of this particular solution. My question to you is, how do we solve the other overarching problem differently? And you're very knowledgeable on the subject matter, and that's therefore why I'm asking you how to solve it. How to solve that problem, the other end of trust,
okay.
The general public.
Are you talking about the review or the investigation?
Both.
Okay. So from the review perspective, and I think I cited the Ferguson Commission report, we would agree that the Attorney General's office should review these cases. Okay. So that's the first part of the question. The second part on the investigation, I think, is a little bit more difficult to answer. But if you are going to have a...
I mean, just to stop you there, isn't our Attorney General an elected office holder?
Yes, he is.
How is that elected office holder more accountable to the general public than a local elected office holder would be?
I think that having someone or an official outside of the area that we're in is actually a good thing, because you aren't, at least from a policeman's perspective, again, I emphasize that because that's the perspective I'm giving you. From a policeman's perspective, you do take politics out of that decision, and at least from their perspective.
It's a bit, I find it's a bit of a contradiction, and again, we're looking for solutions here to a lack of public trust in the current system.
Right.
This is a solution that was presented, and would welcome suggestions of how to improve the current system, which you are presumably here to support, keeping the current system in place, or largely in place. And my question to you is, how do we improve the trust of the general public in a system that currently the general public, I would say, doesn't have faith in?
Well, I mean, one alternative could be to form some sort of multi-jurisdictional task force, or like they have the major case squad. But again, that gets complicated because each jurisdiction would have to provide resources to do that, and I'm not sure how that would all work within the agencies, but that is certainly one possibility where you could have, let's say, another agency doing the lead investigation on one of these incidents.
You represent police officers, am I right?
I
so
do.
I think, could you agree that the protests following the Stockley incident were one, indicative of a lack of public trust in the current system? Would you agree with that?
I think with the people who are protesting, that's pretty obvious, yes.
And would you agree that it is not in the best interest of our police department to have continual protests and continual distrust and continual disruption in our general public?
You're asking me to speak on behalf of the police department, and I won't do that, but generally I agree with the proposition that the less protests, the better. I mean, but I think most people would agree with that.
And I think it would be in the best interest of our police department and the police officers that you individually represent. And what I think we need to do is come up with a solution that gets to the other end of trust, and hopefully we can find a way to work together on that. That's all the questions I have, Mr. Chairman. Thank you.
Thank you.
Alderman Muhammad.
Thank you, Mr. Chairman. I only have one question. And as I sat here and I've read this document again and again for several weeks now, where's the transparency in the current policy?
The transparency is that the investigation goes to the circuit attorney's office for review, and once they make a decision, that investigation, the entire file, is released to the public.
That's not transparency. So if...
Well, that's my view of transparency.
That's cute. So the unit can currently send any information that they want to the circuit attorney, right?
They're going to send whatever evidence they collect.
Can you guarantee that? Because that's not in a policy. It says whatever they get a circuit attorney is what she has. That's what the policy says. It doesn't say all collection, or all evidence, or all information.
Okay.
Right.
What I would assume, though, is, and I'm not part
Assumption. Mr. Chairman, I have no further questions.
Alderwoman, you have a question? Okay. Alderman from the 19th.
Mr. Chairman, I only have one question, but I also have a statement about, for hopefully will be clarified. Have we had an opportunity for the entities to sit down and discuss process and procedure and collaboration? Has that happened?
Not that I'm aware of, but again, I'm only a small part of the web, so I have not. I take that back. I did. Ms. Gardner took a meeting with me in which we discussed some of these issues, but as far as the agencies, and I'm not sure about that. I don't know, ma'am.
Okay, and so let me make a quick statement here. I'm a firm believer that the way we resolve many issues is to sit down at the table and come to an agreement on how process can follow through, and then also have an opportunity to put that into policy. Now, I do know that a few years ago, the Circuit Attorney's Office had their attorneys on call. They would come out to an incident when there was a police shooting and/or an incident that was of a certain level of concern. And they shared that information with us, what their process was going to be. They would be gathering their own information alongside what is going on with the police investigation. I thought that was a good idea. And I even asked them on certain things I wanted to be called in so I could be on the scene too, because I have to answer to my public as well. So I thought that worked okay. I didn't hear any complaints from the police department. I don't think anybody got in each other's way. And so I'm going to continue to listen this afternoon and see where this goes. But for me, and most people know, I do support the Circuit Attorney's Office and the police department, but I support them working together because that's the only way that we can have a civil society, because we need both entities drastically. I don't know how we would live without having policing done based on how the world has this love affair with guns now, and most especially having a love affair with guns that have more firing power than the police department. So I'm hoping that we will have that opportunity to work together, and I think that some of the other things that you talked about with the U.S. Attorney's Office and/or the Attorney General has always been in place, and it is there at the discretion of the Circuit Attorney's Office at any point in time that she would choose to bring them in a situation as well. Is that true?
To my knowledge, that's correct.
Okay. So a lot of this is stemming from, and I think I've shared this with people who have called me, a lot of this is stemming from the fact also that we are new in governing our police department. And so when you've, for so many years, never had the local municipality involved with supervision and policy structure, it's new. It's new. And so everybody is trying to overprotect themselves in a way of speaking. But at the end of the day, our policemen are employees of the city of St. Louis. There are very few places that you can work and tell your employer what to do and what you're going to do and what you're not going to do and how you're going to do it. And so that's a very, you know, that's something we got to clear up soon, because that is a fact that they are employees of the city of St. Louis. I believe that 99.5% of the police officers that we employ try to do the right thing and do the right thing, but we know we got some that have problems. And we know that some people get to a point in their career that creates problems for them based on what they've gone through. And so investigations are important. Investigations that have parallel processes are important, and investigations that have tiered processes are important. And so I'm hoping that we'll have an opportunity to work all this out for the future, because I need both entities. I'm dealing with things I never thought I'd deal with before in my life, when my children can't go to school and be safe, when I can't go to church and be safe, and the list just goes on. I can't even sit in my car and text a message, because somebody will pull up to me and say, Marlene, you know you can't sit in the car anymore on the street, and tell me to move on. So, you know, we've got to work together. We really do. And I do have an overall trust with the police department. We've been in some territories that we have not been in before, with the large amount of protesting that's been going on. A lot of people who have been on the protest movement don't know how to protest. All of us made some errors on both sides. Hopefully we'll get those cleared up as well, and learn how to respect each other in those processes, because no, it's not okay to throw something and hit a police officer. It's not okay to damage somebody's property, but it surely is okay for you to have your First Amendment right and let people know how you feel about something in a peaceful, organized manner. You definitely have that right. And I would fight for you all day long for you to have that right. So we just got to get to the right place with all these issues. And the way you do that is you start off with a bill like this, but I think it's some more work to be done. And I'm going to wait and hear from the Circuit Attorney's Office on how we can move forward. But I'm there to help on both sides. Thank you.
We'd like to thank you for your testimony here today.
Thank you, Mr. Chairman.
We will be, I know you have someplace else to get to, so.
I do.
We do appreciate you.
I appreciate it.
Thank you. We will be calling a second hearing next week, where we'll hear from the Circuit Attorney, as well as our other guest, Redditt Hudson, at that time. I have to schedule it. I don't know what else is scheduled next week. I know you're the sponsor of the bill, but we'll be calling it for Tuesday or Wednesday next week, depending upon what else is scheduled.
Okay.
Did you have any other closing comments here today?
I wanted to say I appreciate everybody's opinion, and I did want to point out that I don't think anybody is against the police, and that's something we kind of got to take out of sometimes saying we are against certain actions of the police. Everybody at some point in time needs the police. You call them. If we walked out of here right now and, you know, somebody fell down some steps, we'd be like, call the police, and they would dispatch us to an ambulance. So we 100% are not against the police. I'm not against the police. I appreciate every officer, any person that's willing to come to my house when I call them and you know, don't know me from don't know me from Frank down the street, to come protect me and my family. So I most certainly appreciate them. But when it comes down to bringing transparency, and we have to start looking at as a city what that actually looks like, and we have to look at as a city what this future holds for us. One big issue that we do have as a city, I think, is we are always trying to handle issues as they arise, not before they actually get here. And that is why we're always running behind our tails, trying to get ahead of everything, because we're not thinking ahead. So when it comes down to the way other cities have been doing things and the way other states have been doing things, we are always falling behind. We are looking at other cities and states for what direction we should be going in. When will we start being innovative? When will we start being the competitors? Right now, we are just following behind laws that everybody else makes. You know, we need to start looking at what we can do for our particular city. The problems that exist here in St. Louis are different from the problems that exist in Kansas City, different from the problems that exist in New York. You might have some of the exact same issues, but there are different people in different cultures, so we have to culturally understand what policing is and who we are policing. That's extremely important. So once again, we're not against the police, but the transparency is what builds community. Transparency is what builds a real relationship. Like you talked about everything being balanced. If everybody does not feel balanced or everybody does not feel like they have a voice, they'll always feel walked over. The people in this city, black, white, Asian, no matter how you want to look at them, a lot of them feel like they are not being adequately served. That's why you saw thousands of them outside our city hall, outside and throughout our city protesting. The people believed in the police department and their actions when certain actions take place, which what we're talking about, the police-involved shootings, then you wouldn't have those thousands of individuals who are out there. You're going to have people who support the police no matter what they do. And, you know, there's nothing wrong with that, because a lot of people have family members, and it's okay to be biased sometimes. But what I want to take out of the police's hands, and that's just being realistic, is the opportunity and the ability for them to investigate themselves. For me, that's what this is all about. If you own a restaurant and you yourself was giving yourself a rating on how good your food was, and that was going to dictate the amount of people you got for service or the amount of people you got to come patronize your business, you wouldn't say I got F rating in food. You'd be like, I got an A, I got a B. You get yourself close if you're trying to stay humble, but if not, you just say I got an A. The same thing when it comes down to discipline yourself. You know, you're not gonna hit yourself the hard as you can hit yourself. Somebody else will. So when it comes down to the police investigating themselves, there'll always be something that might get looked over. As a friend to the police department, as someone who you see every single day going out to protect the city, protect their families, yes, you might find yourself in a bump, and you might make a particular action that you may regret. You may regret, you know, an hour from then or 2 hours from then, or the situation might get blown out of proportion. No matter what, you are police officers, and accountability is necessary when you are dealing with people's lives. So when it comes down to public perception, and that's all being on one page, it's not right for anybody to be able to investigate themselves and tell themselves, you did this right, you did this wrong, when there's supposed to be a balance. So, and that's all we're asking for, whether it's Kim Gardner, we don't know who the circuit attorney is going to be in 4 years. We don't know who it's going to be in 10 years or 20 years, but we have to look at what we want the city to look like as far as transparency 10 years from now. What we actually look at as a city and say, this is what we set in place 10 years ago. This is how things have been working. At the time we set it up, it was Kim Gardner. Now it's such and such. Or it still is Kim Gardner, but we have measured the process, and this actually works. A lot of us don't know. Inside of this bill, we have the authority as the Board of Aldermen to actually produce the protocol in which that special investigation unit will proceed. You know, we just talked about having control of our police station and control over some of the actions and policies. We haven't really dug down into what their policy is. We actually, as a board, have some control over how they would investigate these police-involved shooting if this bill was passed. Now, some of us might not want that authority, but it's not, we're doing the investigating, but we have some authority over how the actual protocol looks on how they investigate. That's where the conversation happens at, when it's more than one person involved. If it's only special interests coming out of either the Kim Gardner's office or coming out from the police, like, you know, everybody's gonna have an interest to some degree, but you have a lot of us are involved, it's a lot easier, or I'm sorry, a lot harder for your special interest to take king over anything. It can't trump everybody's decision. We all have some authority to be able to work together to see what police policy looks like collectively and say, this is how we want them to proceed when this happens. This is how we would like them to proceed when that happens. And we can go back to the drawing board as many times as it takes with the police officers to get to a real balanced situation collectively where everybody feels like they're being respected. I want the police to be safe. I don't want them to do their job tiptoeing, feeling like, you know, if they make a wrong action, they're going to jail. No, that's not what we want. We just want everybody to know that, hey, if I don't do right, I can be investigated, and it won't be by my lieutenant. It won't be by somebody who I see every day when I go to work. And, you know, and that's important for transparency. I just wanted to point those things out. Thank you all for coming. I'm looking forward to next week, sir. Thank you.
Next week. Our circuit attorney will have the opportunity to testify at that time, as well as the other guest, Reddit Hudson, that we will have next week.
Yes, sir.
I have to look at the full schedule. I don't know what else has been scheduled, but once I do that, we'll have it Tuesday or Wednesday or next week.
Okay. Sounds good.
Thank you, Mr. Sponsor.
Thank you, sir.
Appreciate it. That completes our agenda for today. Our meeting is adjourned.